Hi, I'm Greg Dell with Dell Disability Lawyers, back again with Stephen Jessup, and we have the opportunity again to talk about a case that we recently resolved for an attorney. And Stephen, we always talk about the successes we've had for clients, and you're going to tell us a little bit about the background of this particular case, how you were able to help, and then going forward, how we're going to be able to protect the benefits for this particular client. So give us the history of this case.
Yeah, so this was a client. She was a transactional attorney, a partner at a very large national law firm. Prior to contacting our office, she went out on disability on her own. The claim was approved through Prudential. Prudential, though, only approved it on the basis of a mental health condition, and like the majority of the policies, had a 24-month limitation. She hired us to try to assist her in getting them to not see it that way, if you will, to push the neurological issues that were causing disability, since she had filed for both, and Prudential only decided they wanted to look at the mental health because they're paying her a substantial amount of money each month. It's an ERISA policy, so they're doing everything they can to limit it to that 24-month period.
So talk about this 24-month limitation, because sometimes we just talk the lingo because we do it all the time, but what does that mean?
It means that through the life of the policy, if your disability is due, in her situation, the language in the policy was due to, not caused or contributed by, but due to a mental health condition, Prudential would only be obligated to pay a total of 24 months under the lifetime of the policy. So at the end of that 24 months, they could say, well, certainly we think you're disabled, you can't go back to working as an attorney. We wish you the best, but our liability under the contract or under the policy is only 24 months.
So did she call you at the point in time where Prudential had already said, we're only going to pay you for 24 months because this is a mental health issue?
Yeah, she actually called me, as she had already been on claim for approximately a year, trying to handle it on her own. She couldn't deal with the stress of it, and just having to deal with them. So, she contacted our office, and then we got involved at that point.
Yeah, it's interesting you said she couldn't handle the stress of it, and if there's one claim disability in particular that I always tell claimants you should absolutely have a lawyer, it's somebody who has a mental health issue, whether it's anxiety, depression, anything in the mental health aspect, because you're basically telling your employer, I can't handle the aspects of my job. But yet, if you go and then handle your disability claim on your own, the disability insurance company is going to say, well, you showed an ability and we think you probably did an okay job with this to process your appeal or handle your claim, and you're showing full functionality. So if you can do this claim, why can't you do your job?
It also happens when they do interviews, and they'll say, oh, you were able to be attentive, answer questions, it didn't seem like there was any lapses, things like that. So you're right. Handling it shows you have the cognitive ability to do it. So when you're arguing that you don't have the cognitive ability, now granted, handling complex, legal matters isn't necessarily as demanding as handling the claim, but you got to remember the insurance company has every incentive to try to deny you. And from a legal perspective, the law is unfortunately, in their favor in a lot of ways if you end up in litigation. So, it is a slippery slope you can be on. And also when you're dealing with a mental health condition, and like I said, she did have neurological basis, for disabling, restrictions and limitations, which we'll get into. But she was always in this, state of panic and fight, and she was never really getting better. She was never really, the treatment wasn't as effective as it could have been because of the stress they were putting her through.
All right, so let's go through, what was her diagnosis?
Well, without a doubt, she did have a history of depression and anxiety. There's no question about it. But then there was also, interestingly enough, from a neurological perspective, there wasn't necessarily a working diagnosis from a neurological. Brain MRI showed that there was some atrophy and some white matter issues, but wasn't multiple sclerosis, wasn't anything like that. But there was some frontal lobe issue. And then, so working with that, we got her in touch with a neuropsychologist, and explained what the issues were, provided the neuropsychologist with all the, the neurologist reports. Her neurologist has been incredibly supportive that, in his opinion, that the issues that he's seeing on the brain MRI, although they don't have a firm diagnosis, could account for some of the symptoms and the issues that she's having. So the neuropsychological testing did show across the board that she had issues in concentration, executive functioning, processing speeds, memory, stuff like that. And couldn't overlook the fact that she had a history and quite a bit of treatment for the mental health. But the neuropsychologist at the end of in the report and looking at how all the scores came up said, even if we separate her mental health issues, based on the scoring, it's clear it's a neurological process that's causing these issues, and it gave the the formal diagnosis of mild neurocognitive disorder. So all this was done in advance of the end of this 24-month period. We submitted that over to Prudential, and for a while it was radio silence. And I believe we also briefly discussed this case because she had a policy with Principal, same type of language, and we got Principal to agree that it was, a non-mental health situation. But that was an individual policy versus this ERISA group policy where we know the law is just going to be a lot more, it's contentious. Prudential has every incentive to continue to deny, so it was quiet from Prudential for a while. It's almost like they forgot about the case. And then six months approximately after the transition of that 24-month period, they're still paying benefits. And then, we got the indication that, oh no, we had our doctors review everything you sent, and we believe that it's still a mental health condition. So in the appeal, it was then a matter of really hyper-focused, because I'd had this client for a while. There had been a lot of back and forth with the doctors, a lot of work up to it. During the appeal process, we then really worked with the neuropsychologist and the neurologist again to review the reports done by Prudential's peer review doctors. And the neuropsychologist, was very, very strong in the language about what the testing showed, all this type of stuff. And credit to whoever the neuropsychologist was. They didn't name them in the approval letter, and we won't know because we can't get the claim file. But they quoted a lot of her report and indicated that across the board she believed it was a neurological process, that it wasn't meant, even same as our doctor, that yes, there's a history of mental health, we separate that out and she wouldn't be able to do her job duties. So, Prudential advises they're overturning the denial.
When you got the claim file, which is the documentation you get after benefits are denied, did Prudential initially have your neuropsych report reviewed by a neuropsychologist?
Yes.
And so now, interesting that on the appeal, they hired a second neuropsychologist because under the ERISA regulations, they're not allowed to go back to the initial doctor they worked with, and this doctor disagreed.
Yeah,
with the doctor that Prudential hired previously.
It almost felt like she was just reiterating what our doctor had to say about it. It was so in point with it. You see it a lot too. A review by a neuropsychologist, they'll say, well, I reviewed the data and I don't think X, Y, and Z. One great thing about this doctor that she had the testing with, he's very meticulous about all the embedded validity measures and all that type of stuff, because we see a lot of times people have their own testing done. And there's either an issue where they don't do certain tests, so the insurance company says we can't trust this as valid, or a real big thing here is the premorbid functioning. So we've seen it for people who are extremely intelligent, high-level executives, and the neuropsychological report they had done is saying, well, everything's average, so there's nothing wrong. Well, they're not an average person. You have to look at where they should be based upon training, education, experience, and then interpreting all the data in context of that.
And then I know when after the appeal came in and you were working on this appeal and we were discussing the strategy, talk about how you went into the occupational duties and how that related to, and you touched on in a second, about how high-level functioning attorney, but then really stressing on the appeal the responsibilities of a lawyer and articulating that to the person who's reviewing this claim who's a non-lawyer.
In all honesty, there was never a question about the vocational. It was always a matter of, is this mental health or not? And their position was mental health. They never questioned whether or not she could do her job duties. They more or less said, we don't think you can, but we only have to pay you this amount of time. So all the legwork about the occupational duties and demand were done prior to the denial, because that was all integrated with the neuropsychological testing, and then the letters and supportive letters and stuff we got from her doctor, job description. So they never really attacked the vocational. They really just attacked, is the medical verify it's not a mental health condition. Like I said, it was difficult because we didn't have a firm neurological diagnosis. The closest we had was the mild neurocognitive disorder. And sometimes people go, oh, it's just mild. Well, there's two types, mild and major is dementia or late stages of Alzheimer's. So it was a tricky one. And knowing Prudential, and we've litigated with them so much, I was very honest with her. She was a lawyer. I'm like, there stands a good chance we're going to find ourselves in litigation just because the way this law works and the way the insurance companies act under it. Like I said, she had the individual policy, different creature altogether. That's treated much differently. So it was a very, very good win. But I knew it was a strength in the testing and finding the right doctor, having the right doctor do the testing and working with that doctor so they understand, and then the neurologist, backing up the opinions.
And what a lot of people don't know, and the way in which how you won this particular appeal is the manner in which you worked with the neuropsychologist, because, and the reason that's so important and why somebody who doesn't have a lawyer could almost never do this is because, let's say this particular client didn't hire you and then came to you and said, look, Steve, I got denied, and they just gave you the file. In ERISA, we're bound by the record. We're bound by everything that was done up until that final denial. And when we go to litigate and we put these cases in court, we can't call the doctor to testify 99% of the time. We can't bring in new evidence. So what we're doing during the appeal, which requires such a high level of legal work, is you're basically presenting your case, not just to Prudential, but to the court, to the judge. We're talking to the court. So, you know, it's amazing that you were able to do this, and it's great that you got this work, but we also get so frustrated often because we see files either people have done on their own or they've gone to lawyers who don't know what they're doing, and we're stuck with, there's no other way to put it, crappy appeals and facts that aren't good, and we look at it and we go, damn, I wish we could have done this, and that, because we probably would have won the appeal, but if not, we'd have so much better chance now to win this case at suit. So
you're so right. Even in mediations, I've had defense attorneys go, if only they had, you know, only X, Y, and Z had been done, this may have been different, you know, and you're bound by what's in that record. So it's so important to lay the groundwork.
So I think there's just so many things that could be done in the appeal and going beyond the treatment. And look, it's not easy. You need a cooperating doctor. You need a doctor who's passionate in advocating for their client, although there's a line between treating and advocating. But unfortunately in this world, if the doctor's not willing to advocate for the claimant / patient, it's hard to win these cases. And Prudential banks on that. That you're not going to find a doctor who's going to rebut this, because we're Prudential, multi-billion-dollar company. We're going to hire an expert who's going to just tear apart your medical records, and that's all we need to do.
Yep. And even in this appeal process, while it was going in there doing the review, they kept requesting the updated mental health records. They wanted to see those. And I've replied to them like, she's already met 24 months into that. Has nothing to do. This claim is purely about the neurological process.
Right. Now, she's not completely out of the woods, because they're going to constantly ask for medical records, especially in mental health, and you're going to have to always review those medical records and remind her you have to go to the doctor, and if you continue to have these complaints, you have to document them, because every 3 months or so, Prudential is going to request those medical records, scrutinize them, probably have them reviewed again, even though we have a neuropsych that's saying you have a brain injury. Brain injuries don't heal.
And especially as you get older, it's like a bad back. It's going to get worse or stay, you know, the same at best. And you know, we're already setting up and calendared it at about a year from the last testing to look to do the repeat, to avoid them trying to send her to their own neuropsychologist.
Really smart. Well, congratulations for your client, for you on a great job. If you're someone out there who has a Prudential long-term disability insurance policy, feel free to contact Stephen or myself. No matter where you live in the country, we're available to assist you, and we look forward to providing you with a free phone consultation.